Here we go. The Illinois State Rifle Association says that they anticipate this being a 2026 case, not a 2025 case, as some may speculate going into the new year with the gun ban up in the appeals courts for the federal jurisdiction. While you've got another case out of Maryland in front of the U.S. Supreme Court, and we'll see what happens there. Obviously, we've been tracking this since the law was enacted in 2023. And where we're at right now, I chatted with Illinois State Rifle Association's Ed Sullivan to get his reaction to the lay of the land when it comes to the state's gun and magazine ban. This is part of the conversation I had with Ed Sullivan on Friday.
Well, what we know is there's been several lawsuits filed in regard to the so-called assault weapons ban from a few years ago. They're working through the court system, kind of how we expected. We've seen no surprises to date. We obviously believe that Judge McGlynn's ruling the other day is the correct ruling. And now we just have to wait for the Seventh Circuit Court of Appeals to take up the case at some point. It would be our hope at the Illinois State Rifle Association and others that have their cases before them that this would take place in January. We're kind of hopeful, but we don't control the clock, and we're waiting on the Seventh Circuit Court to tell us what their schedule is going to be.
So we don't have that schedule yet, but you've got reaction from across the spectrum on the issue of gun control. The Illinois Attorney General said that they're pleased with the Seventh Circuit's ruling, keeping the gun ban in place, saying that the Protect Illinois Communities Act is an important tool to prevent weapons of war from being used in our schools and on our streets. Attorney General Kwame Raoul saying that he is committed to defending the law's constitutionality. You've got others making similar comments here. This one from One Aim Illinois, another gun control group. Let's pull this up so you can read along. It says, One Aim Illinois responds to federal appeals court's decision to temporarily uphold the Protect Illinois Communities Act. The decision by the U.S. Appeals Court to temporarily uphold the assault weapons ban is an important step toward safeguarding our communities while the legal process continues. High-capacity firearms and rapid-fire capabilities present a significant threat to our families and our communities. These weapons are not suited for civilian use, and time and again, we have witnessed the devastating tragedies that occur when they fall into the wrong hands. And the comments go on from there. Sullivan reacting to this this term that's used quite a bit, weapons of war, whenever the debate about what kinds of firearms can ultimately be owned by law-abiding citizens.
Well, you know, they have to demonize something, and so they're going to demonize a commonly used firearm, yet they'll do nothing about the violence that's plaguing our communities as we speak. I looked at the data the day that or the week that the tragedy took place in Highland Park. There was the equivalent of 27 Highland Park shootings in the first 6 months in the city of Chicago. 27. And so if you add up all the deaths and all the 7 deaths times 27, that's what you saw. And where's the outcry for the deaths and the destruction of our communities in the city of Chicago? Yet we're going to go after, you know, something that we need to demonize to make it look like we're doing something about violence, when the reality is they aren't.
So again, Sullivan laying out some of his reaction to the gun control lobby that says these are weapons of war. You've also got GPAC, another gun control group, putting out a statement saying they welcome the Court of Appeals action. Means that Illinois' ban will continue in effect until the appeal from Judge McGlynn's order is decided. Illinois citizens will continue to be protected against weapons designed for military purposes that no one needs for self-defense and are weapons that are choices of criminals who want to cause maximum destruction. So again, this idea of weapons of war, that terminology, but also saying that they're designed for military. Well, the district court went through that in painstaking detail. I sat through 4 days worth of that bench trial where they went down the gamut of all of the different firearms and how no military across the world issues semi-automatic firearms, how they're made differently to be able to undertake a substantial amount of stress for military firearms, and so on. So the district court built that record, and that record is now in the appeals court. How they're going to handle this is interesting, especially with the panel of the 7th Circuit U.S. Court of Appeals being the same panel that took the preliminary issues, but they did add another judge to replace the outgoing judge on the original 3-judge panel. So you've got the judges there. One in particular, Frank Easterbrook, who was really driving this argument of, well, these are too similar to military grade firearms and can be banned. Ed Sullivan with the State Rifle Association pushed back on all of that, but he wonders if really the record from the Southern District is going to sway anybody.
Well, it's interesting. I mean, my first reaction would be no, Frank Easterbrook is not going to be on our side. Yet, the last time we heard him speak, he said, I'm open to being persuaded. With that, I think Judge McGlynn really tackled the issue head on and did a very good job trying to, take this issue of military grade versus civilian use. Obviously, the simple AR-15 and firearms similar to those are not military grade. They're used in everyday situations, from target practice to hunting to all kinds of things, to home protection. They don't have fully automatic or short burst automatic. So there's obviously huge differences between the two. And I think, we'll see what happens at 7th Circuit Court. I'm fairly confident we'll prevail at the Supreme Court.
But before that, you've got a whole host of other cases. You've got several still in the 7th Circuit challenging local and statewide bans, like the Beavis v. Naperville case, which also includes a challenge of Illinois' ban. You've got the Veramontes case, which has already been heard by the appeals court, waiting on some kind of outcome there. But there are other cases circulating in the federal judiciary, including Maryland's case out of the U.S. Supreme Court. They could possibly take a look at this later on this week in a conference, and we could know next week, Monday, what they're going to do with that case, either relist it or decide to take it up. But what's the timeline look like for Illinois' gun ban challenge, especially the one that was final judgment in the Southern District and is now in the appeals court? Sullivan saying that, he sees it possibly going into not 2025, but 2026.
In a best case scenario, we get some type of ruling by March. Obviously, if they rule in our favor, then we get what we want, and the law is upheld. March is critical because that's where we could file for cert and still have a potential prospect of being before the U.S. Supreme Court this summer. I don't want to, let the world, I guess I don't want to have people that are on our side be upset about this, but I think this is a 2026 case, quite frankly. I don't see how that the 7th Circuit Court is going to get all this done and heard, which we anticipate them ruling against us. And so that's the basis of what I'm saying by 2026. But that would be nice to get it done in 2026 and have this whole issue put to bed. But this is a national issue. This isn't just Illinois. I mean, this is a case that, whether it's the Illinois case or whether it's the Maryland case, this is a national case. And so it's going to have national implications.
But what about that Maryland case? The U.S. Supreme Court has a conference Friday where they could consider taking it. We could get a conference report on Monday. Is that going to do anything?
It certainly could. There's no doubt. I haven't really taken a look at where their process is right now. I know our process is one that, I believe at this point, the earliest it'll be is 2026. I just don't see the 7th Circuit Court, moving at the pace that we would like them to move at. And so certainly Maryland could pop in before us, which is, once again, that's a case teed up for national implications. And so that would be helpful as well.
Again, no update on the timeline from the appeals court when they plan to hear this, let alone brief this. So we'll be watching that closely here with Illinois in Focus Daily. Wake up with us each and every weekday morning. with headlines in your inbox. Go to thecentersquare.com, sign up for the newsletter. Also get the podcast where you get podcasts. Just search Illinois in Focus. But if you want to wake up with us live each and every weekday morning, it's right here with America's Talking Network. I'm Greg Bishop. This is Illinois in Focus Daily.